Our sessions today, both morning and afternoon, are going to be moderated by Liz Mancusi. She is a staff attorney at CUNY Citizenship now. I'm going to let her introduce herself a little bit more. And it's almost 10 o'clock, so I think we can get started. What do you think?
Sounds like a good
Right?
idea.
Thank you so much, Liz.
Thank you, Alan, and everyone who came this morning, and to all of you again, thank you so much. I think we have a really great training prepared for you today. And for those of you, again, who were not able to make it here today and are watching from the live stream on the internet, I just wanted to mention that throughout the presentations, you may have questions that arise and you will have an opportunity to ask those questions. I recommend that those watching from home or their offices, depending on where they're using the internet, not wait till the end to type their questions so that there is an opportunity for the folks monitoring that to write the questions down and present them to Tamara Bloom, who's a staff attorney at CUNY and who's done a tremendous amount of work putting this together today, so thank you, Tamara. And she will be asking the questions. In addition, for those of you who have been here before, during the Q&A sessions, we're changing the format a little bit this year, again, to sort of support the live stream in terms of how the microphone will work. We're going to ask you to use the index cards that were provided to you this morning to write your questions down, and ask that you pass them towards the end of the aisle, maybe make a motion with your hand. And we have CUNY staff that are going to be positioned in the aisles, waiting an alert to see the questions being passed over, and they will be forwarded to the front and asked at the end of each session to the individual speakers. So in terms of introducing myself, I'm going to be very brief. I am a staff attorney part-time at the LaGuardia Community College Center on Mondays and Wednesdays. I've been with CUNY Citizenship now for the last 2.5 years. Prior to that, I was in private practice for a few years after graduating from CUNY Law School, where I worked on an asylum case in my final year during the removal proceedings of a young gentleman, and that experience sort of led me to know that my passion was to work with immigrants in this community. I also, in my other job, am the director of an immigration project with an organization called Volunteers of Legal Service, and so that is another group of individuals, lawyers that work at large firms that work with children, and I am the co-chair of a pro bono committee with the American Immigration Lawyers Association, who I know is a big partner this year, contributing many lawyers who help supervise the callers and answer more technical questions. So we thank them for their assistance. So before we have our first speaker, Maggie Kawinski is a staff attorney at CUNY Citizenship now. It's my pleasure to introduce her. She's been with this project since 2006. She is currently the staff attorney at the College of Technology and Immigration Center, and that is in downtown Brooklyn. She is a graduate of CUNY Law School as well, in class of 2005, where she worked also in the Immigrant and Refugee Nights Clinic. She's originally from Western New York, and she received her bachelor's degree from SUNY Buffalo. Maggie?
Good morning, everyone. Welcome. All right. Before I begin, please note that we have detailed citizenship materials available in our CUNY Citizenship Now Read Me First guide. You can find the guide online at www.cuny.edu/citizenshipnow. Also, volunteers will receive a copy of this guide at the call-in. Okay, let's move on to naturalization. So the benefits of being a U.S. citizen, or as I'll refer to, a USC, include the right to vote. There are also family-related benefits. USCs can apply for married children, parents, and brothers and sisters. Lawful permanent residents, or LPRs, cannot. Also, The waiting time for receiving a visa is much shorter for relatives of U.S. citizens. Public benefits. U.S. citizens can receive all public benefits without the complicated rules and limits that non-citizens face. Such benefits include SSI, temporary assistance for needy families, Medicaid, and food stamps. Non-citizens aren't always eligible for these, or if they are eligible, it's on a very limited basis. USCs are also eligible for all government employment. Many federal, state, and local jobs require U.S. citizenship. For example, the NYPD. Traveling to other countries when you're a USC is easier too. Many countries don't require a visa for U.S. citizens. Also, you can live outside of the United States for unlimited periods of time and re-enter. LPRs, on the other hand, might not be able to re-enter if they leave for 1 year or more. Most importantly, U.S. citizens are protected from deportability and inadmissibility. Inadmissibility refers to not being allowed to re-enter the U.S. after traveling abroad. Other benefits include the ability to run for elected office and to serve on a jury. Okay, let's move on to the next slide. Eligibility requirements. Please note this list is in your call-in manual on page 1. Applicants for naturalization must be at least 18 years old. There's an exception for those who served honorably in the U.S. Armed Forces during an authorized period of conflict. These periods include World War I, World War II, the Korean War, the Vietnam War, the Persian Gulf conflict, and the post-9/11 conflict, which continues to this day. Don't worry, you'll have this list available to you at the call-in. It's in the Citizenship Now Read Me First guide that I mentioned earlier. Continuous residency concerns the specific period of time before an LPR is eligible to apply for naturalization. And the length of time usually depends on how they obtain their permanent resident status. We'll get into the details in future slides. Physical presence concerns the total number of days the applicant was actually in the U.S. during the period required for naturalization. The applicant must have been physically in the U.S. for at least half of this required period. And again, we'll get into the details in future slides. Applicants for naturalization must demonstrate good moral character. This is a very broad requirement, and we'll cover it later in future slides. For now, just note, good moral character problems are not always only criminal. Most naturalization applicants are required to pass an English test and must demonstrate an understanding of the English language, including an ability to read, write, and speak words in ordinary usage in the English language. There are exceptions, and we'll cover these exceptions too. Most applicants must also pass a U.S. history and government test. The test questions are taken from a USCIS list of 100 questions. And again, there are exceptions to this requirement as well, and we'll cover those. Lastly, applicants must understand and accept the oath of allegiance to the United States. You must show that you are attached to the principles of the Constitution and are well disposed to the good order and happiness of the United States. If you object to certain parts of the oath, you can ask to take a modified oath to exclude the objectionable parts. We'll cover these circumstances at the end of the presentation. Let's move on to the next slide. On to continuous residency. 2 things to remember here. The applicant must be an LPR for a specified period of time. And throughout that specified period of time, the U.S. must have been the applicant's primary home. Examples of home include where you work, where you go to school, where you file your taxes, where you have family, where you own property, etc. The general rule is that the applicant must have been continuously residing in the U.S. for at least the past 5 years as a lawful permanent resident, up until the date of naturalization. There is an exception for those who are married to a U.S. citizen who have been living with that U.S. citizen spouse for the past 3 years. The continuous residency period in these cases is only 3 years. If the couple was living together for 3 years but they just got married last year, it doesn't count. Remember, the spouse must be a citizen for 3 years. The marriage must be at least 3 years old, and the couple must have lived together for the past 3 years. There's also an exception for those who got their green card as the spouse or child of a U.S. citizen under the Violence Against Women Act. These LPRs are also eligible to apply after only 3 years of continuous residence. Just 2 more notes on continuous residence. First, the applicant must have lived in the U.S. CIS district in which they are applying for citizenship for at least 3 months before filing their application. If the applicant happens to move to another U.S. CIS district after filing, they can request a transfer of the application and they must notify USCIS of their new address. Second note, the naturalization application can be filed 90 days early or 90 days before the completion of the 5 years or the 3 years. So you can apply after 4 years and 9 months or after 2 years and 9 months of continuous lawful permanent residence. Let's move on to the next slide. There's also a military exception. Lawful permanent residents with at least 1 year of honorable service are exempt from residency requirements as long as they file while they are still in the military or within 6 months of having been honorably discharged. This information again is available in the Citizenship Now Read Me First guide, which you will have available to you at the call-in. There are special rollback rules for refugees and asylees. Refugees and asylees are eligible to apply for their green card after having lived in the U.S. for at least 1 year. After they're approved for lawful permanent residence, they get credit for this 1 year in different ways. The continuous residence period is still 5 years, but refugees can begin to count the 5 years from the date they arrived in the U.S. It doesn't matter when they actually obtained their lawful permanent residence. The residence since date that's written on their green card will be backdated to the day that they arrived in the U.S. Asylees, on the other hand, asylees must wait for 4 years after obtaining lawful permanent residence. When their green cards are approved, their residence since date on their green card is backdated only 1 year, so they must count 5 years from this date. Continuous residence can be broken, and if it is, an applicant is not eligible for naturalization. Let's review the meaning of continuous residence. Remember the 2 points. The applicant must be an LPR for a specific period of time, and throughout the specific period of time, the U.S. must have been the applicant's primary home. Trips out of the country for less than 6 months do not break your continuous residence, but when an LPR takes a trip outside of the U.S. for 6 months or more, but less than 1 year, USCIS may question the applicant to decide if continuous residence has been interrupted or broken. Remember, the time period at issue is the past 5 years, or the past 3 years, depending on under what section you're applying for naturalization. For trips of longer than 6 months, the applicant must show the USCIS that his or her continuous residence in the United States was not interrupted and not broken. To do so, the applicant can show that his or her job, residence, and/or immediate family members remained in the U.S. during this applicant's long absence out of the U.S. If the USCIS decides the applicant's continuous residence has been broken, the applicant must start counting the 5 years or the 3 years all over again as of the date the applicant returned to the U.S. from the trip that broke the continuous residence. It's a different situation for when people travel out for longer than 1 year. If a lawful permanent resident leaves the U.S. for 1 year or more, continuous residence is generally considered to have automatically been broken. For applicants who broke their continuous residence by an absence of 1 year or more, the rule is 4 years and 1 day. The applicant must wait 4 years and 1 day after the date of return to the U.S. For persons eligible under the 3-year rule, the waiting period is 2 years and 1 day after return. Abandonment of residence. If a lawful permanent resident leaves the United States and makes another country his or her primary home, USCIS may decide that that person abandoned his or her permanent residence, and they can take away that person's green card. There are exceptions to this, including for LPRs who serve in the U.S. Armed Forces or on U.S. ships, or who go abroad to work as employees of the U.S. government or an international organization. Also included are certain lawful permanent residents who serve abroad as religious workers. But as a general rule, if an LPR has lived outside of the U.S. for 1 year or more, and that lawful permanent resident did not apply for a re-entry permit before leaving, that person will be considered to have abandoned their lawful permanent residence. This person has a green card that's no longer valid for re-entry into the U.S. and they should apply for a returning resident visa at the U.S. consulate abroad. Without a returning resident visa, the person can be denied or paroled into the U.S., and parole just means physically let in, but not as a lawful permanent resident. They can be paroled in just to be placed into removal proceedings. Also, note that naturalization applicants who are found to have entered the U.S. at some point in the past without a valid visa, they can be placed into removal proceedings also. On the N-400 application, applicants are required to write down every trip taken outside of the United States. So what is the difference between physical presence and continuous presence? Remember, continuous residence concerns the time that an LPR resided in the U.S. without any single absence long enough to break the continuity. Physical presence, on the other hand, concerns the actual total number of days that the LPR was in the U.S. during the required period for naturalization. The applicant must have been physically in the U.S. for at least half of the past 5 years, or half of the past 3 years if applying under that section. Note that the time does not need to be continuous. For example, it doesn't need to be 2.5 years continuously. It just needs to be 2.5 years over the past 5 years. And as with continuous residence, there are exceptions for certain military personnel, religious workers, employees of the U.S. government, and international organizations. These lawful permanent residents can count their service outside of the United States as time of physical presence. The N-400 application for naturalization requires the applicant to list all trips taken outside of the U.S. since obtaining lawful permanent residence. Remember, trips of more than 1 year can cause an LPR to lose eligibility for citizenship, or worse, be seen as having abandoned his or her permanent residence. Please note that the U.S. includes territories of Puerto Rico, Guam, the U.S. Virgin Islands, and the Northern Mariana Islands. Applicants should check passports for entry and exit dates. If the applicant doesn't have the old passports or remember the dates, the applicant should answer the question to the best of his or her memory or knowledge. Applicants with prior arrests and or convictions should always consult with an immigration lawyer or BIA accredited representative before submitting any application to USCIS. Certain convictions can make a lawful permanent resident deportable, even if the conviction was from many years ago, even if the record was erased or sealed, even if the time was served or the probation was completed or the fine was paid, or the conviction was in another country. When you apply for naturalization, all arrests must be disclosed to USCIS. And USCIS will take your fingerprints, and the FBI will send the fingerprint results to USCIS, and they will know about all arrests regardless. Again, if an applicant has ever been arrested, please encourage that applicant to contact an immigration lawyer or BIA accredited representative for assistance. It's a very complicated area of law. Like I said before, to be eligible for naturalization, an applicant must demonstrate that he or she has good moral character for the 5 years or the 3 years before applying for naturalization. Although USCIS can consider conduct outside of this 3 or 5 year period. It's important to note, as I said before, that good moral character problems are not always criminal. USCIS has the authority to define actions that indicate a lack of good moral character, and we'll get into some of these. There are 2 particular convictions that are permanent bars to naturalization. A conviction for an aggravated felony on or after November 29, 1990, and a conviction for murder at any time. If you have these 2 convictions, you are facing a permanent bar to naturalization. If an applicant is in doubt about good moral character questions, again, please encourage that person to talk to an immigration lawyer or BIA accredited representative. Even if certain convictions cannot make an LPR deportable, it can make that person ineligible for naturalization if the criminal act occurred within the past 5 years or the past 3 years. In addition, if the lawful permanent resident is currently on probation or parole, that permanent resident cannot become a citizen until the probation or the parole is completed. This slide lists a selection of types of offenses to look out for. For example, you may not have good moral character if you were convicted of domestic violence, Domestic violence can also be a deportable offense. Convictions for selling or possessing drugs can make a person deportable, and as a general rule, all drug offenses are extremely dangerous and serious for immigration purposes. If the LPR lied to the USCIS to get a green card, that person may not have good moral character. This is known as immigration fraud and may also result in deportation. If the LPR was arrested for drunk driving or being drunk in public, and particularly if there is more than one such conviction, USCIS might decide the applicant does not have good moral character because he or she is a habitual drunkard. The applicant in such a situation may be expected to demonstrate rehabilitation. An LPR who worked as a prostitute, hired a prostitute, or sold the services of prostitutes may not have good moral character and may be deportable also. Illegal gambling. An LPR may not have good moral character if the majority of his or her income comes from illegal gambling. Lastly, please note that all citations and arrests, even for traffic violations like parking and speeding tickets, should be disclosed on the N-400 application. But you don't need documentation of the incident for traffic fines and incidents that didn't involve an actual arrest or where the penalty was a fine of less than $500 or points on your driver's license. As I mentioned before, the review of one's good moral character is not limited to criminal acts. Taxes, child support, and selective service. We'll cover these more in detail in the next couple of slides. Crimes outside of the 5 or 3 year period and other unlawful acts can lead to a discretionary finding of lack of good moral character. In certain cases, such crimes and unlawful acts can also lead to deportation. Examples include lying in order to get public benefits such as food stamps or Medicaid, lying on a green card application, saying you were single when you were actually married, claiming you did not earn money when you did in fact have an income, claiming you were a citizen when you were not, registering to vote, voting, ever having been a member of a political movement against democratic ideals, being a communist, helping someone enter the U.S. illegally, and lastly, being married to more than one person at the same time. Since becoming a lawful permanent resident, the applicant must have filed taxes every year that he or she was obligated to file. At the naturalization interview, the officer will expect to see the applicant's tax returns that were filed during the last 5 years or for the last 3 years. If taxes were not filed for any of these years, the applicant should have documentation prepared to show why he or she was not obligated to file. If an applicant hasn't paid all his or her taxes or hasn't reported all money earned to the IRS, the applicant might not have good moral character. For applicants who have filed all required taxes but owe money to the IRS, as long as there is a payment plan in effect and they're making payments, good moral character can be demonstrated. For applicants who live apart from their minor children, child support is often an issue, particularly for men. If an applicant is under court order to support his or her children or spouse, and he's failed to do so, the applicant can be found to lack good moral character. In these circumstances, the officer will likely ask for evidence that shows financial support of all minor children, even those living outside of the United States. Even if the support's not court-ordered, some officers will still require the applicant to show evidence of child support for all children under the age of 18. Evidence of child support can include canceled checks, money order receipts, and affidavits. As a general rule, males who were born after 1960, who lived in the U.S. between the ages of 18 and 25, so that's starting on their 18th birthday and ending on their 26th birthday. These males were required to register for selective service by their 26th birthday. If an applicant knew he was supposed to register but failed to do so, he may not have good moral character. This applicant may need to wait 5 years or 3 years after the failure, after his 26th birthday. But generally, if the reason that a male failed to register because he didn't know that he was required to do so, he is not barred from showing good moral character. Most naturalization applicants must pass a test on speaking, understanding, reading, and writing basic English. The USCIS officer will test the applicant's ability to answer questions about his or her citizenship application during the interview. The applicant will also be tested on his or her ability to read and write at least one sentence using vocabulary words found on a list that is published by the USCIS. The list is called the Reading, Writing, Vocabulary for the Redesigned Naturalization Test. It's available on the USCIS website. Additionally, most applicants must pass a test on U.S. history and government. The test questions are taken from a USCIS list of 100 questions. Applicants are given 10 questions and must answer at least 6 of them correctly. You are given 2 opportunities to pass the test and 2 separate interview dates. Please note there are exceptions and waivers to the English test and to the civics test, and we'll cover these in later slides. We'll cover it in this slide. All right. So certain older long-term permanent residents are exempt from the English requirement. These applicants can take the civics and history test and have their interview in their native language. It's 2 general rules, and we have them laid out here on the slide. The applicant must be at least 50 years old and have lived in the U.S. for at least 20 years as an LPR, or the applicant must be at least 55 years old and have lived in the U.S. for at least 15 years as an LPR. Easy way, 15, 50, 50, 20. I'm sorry, 15, 55, 50, 20. They both add up to 70. Additionally, USCIS, right? 70. Yeah. Additionally, USCIS gives special consideration to naturalization applicants who are at least 65 years old and have been living in the U.S. as LPRs for at least 20 years. These applicants aren't giving their usual 100 questions. Their test is only 20 questions, and again, they'll be asked 10 and must answer at least 6 out of the 10. Applicants who have a disability that prevents them from learning or remembering the required information can qualify for a waiver of the English and/or the civics test. To apply for the disability waiver, USCIS must approve Form N648, Medical Certification for Disability Exemption. The N648 must be completed by the applicant's medical doctor, osteopath, or psychologist. The disability must be a physical or developmental disability or a mental impairment, and it must be permanent or expected to last at least 12 months. Examples of qualifying disabilities include mental retardation, Down syndrome, autism, cerebral palsy, schizophrenia, dementia, Alzheimer's disease, chronic depression, bipolar disorder, panic attacks, paranoia, and PTSD. Not all disabilities qualify for a waiver, and please note that old age and/or illiteracy do not qualify for a waiver. Earlier I said that the oath requires the applicant to show attachment to the principles of the Constitution, and that he or she is well disposed to the good order and happiness of the United States. I'm going to read you the oath in simple and informal English. Here it goes. I swear that I will no longer be loyal to the government of any country where I used to live. I will support the Constitution and the laws of the United States. I will defend the United States from all enemies within and outside the country. I will serve in the armed forces, do non-fighting work, and help with important national work when required by law. I take this oath freely and without any doubts. After the applicant passes the naturalization interview, he or she needs to stay eligible for citizenship until the oath ceremony. If the applicant does anything that may cause him or her to lose eligibility between the interview and the oath, that person may not be sworn in as a U.S. citizen. Remember, a person is not a U.S. citizen until they are actually sworn in. So even though your application for naturalization may have been approved, it doesn't go hand in hand. You have to go to the swearing-in oath ceremony. Some people are not able to take the full oath because their religion or moral beliefs bar them from swearing allegiance or fighting in the military. Applicants can request a modified oath for religious or moral beliefs. They just need to attach a signed statement explaining what changes they're requesting and why. For members of organized religions, a letter from the leader of the church, the mosque, the synagogue, or other faith institution should also be attached. Severely disabled applicants who can't understand or communicate the understanding of the oath can also get a waiver. The request can be made at any time during the naturalization process. The oath waiver must include a written evaluation completed by a licensed medical or osteopathic doctor or licensed clinical psychologist. Applicants who can't afford to pay the naturalization filing fees can apply for a fee waiver. There are 3 categories of applicants who can apply. Those receiving a means-tested benefit from a state or federal agency, such as food stamps. Those whose household income is at or below 150% of the federal poverty guidelines. And those who have a financial hardship due to extraordinary expenses or other circumstances. The USCIS decides whether to approve or reject the request for a fee waiver. There is a new USCIS fee waiver form. It's Form I-918. And detailed guidelines on the form and the form itself are available in the training manual starting on page 69. This information is also in the CUNY Citizenship Now Read Me First guide, which you'll have available to you at the call-in. Note that the filing fee for naturalization is $595, plus a biometrics fee of $85. And note, applicants 75 years old or older are not required to pay the biometrics fee. For future reference also, this filing fee information and the N400 mailing address is on page 2 of your call-in manual. And I'm done. Thank you.
Thank you, Maggie. I just wanted to touch on a point that Maggie made regarding the arrests. I sometimes think that examples really help illustrate information, and you know, when we're trying to help folks with their applications, we always have to remember a really important sort of catchphrase, which is, I always remember hearing at a training that I did, which was do no harm. And there are certain individuals who may think about an arrest as an arrest that was dismissed, and then when you actually ask for the disposition, you'll find that they really pled guilty and paid a fine, and it was a long time ago, and their memory of it, especially if there was a language barrier, if they were represented by a lawyer who maybe didn't explain what the actual plea was being taken. So anyone who's actually working with immigrants on naturalization applications should always ask for the disposition, or folks should be encouraged to obtain that first when they go and seek help. An example was someone who I met who said he had a traffic violation, a little car accident, and that would seem like something you wouldn't want any sort of disposition for. And when I still insisted that he had it, it turned out it was vehicular manslaughter. Kind of a different sort of perception of the arrest based on where you're coming from. And I'm sure he was very embarrassed, and I felt really bad, insisting on it. He was an older gentleman, but it's really important to understand the consequences of what you're applying for. So you're not always helping someone fill out an application if you're not doing it, which is why I think Maggie was right to encourage you, to insist that someone sees someone who has a particular expertise in dealing with the consequences of criminal convictions, and that be a lawyer or a BIA accredited rep that's trained in that area.